Today we'll be talking about the evolving legal framework applicable to cross-border flows of personal information. Canadian organizations carrying on activities internationally should understand how the cross-border flow of personal information contained in their CRMs and other databases, including information about their employees or customers, is regulated. In Canada, PIPEDA is the centerpiece of privacy and data protection and was enacted, at least partially, in response to the European Union Data Protection Directive of 1995. Certain provinces, such as Quebec, Alberta, and British Columbia, have adopted substantially similar legislation to PIPEDA and cover the protection of personal information in those provinces. In Europe, the Data Protection Directive regulates the processing of personal information within EU member states. These member states are required to pass legislation that restricts the transfer of personal information to non-EU countries unless those countries provide for an adequate level of protection of personal information. The directive also allows for transfer to entities which have implemented safeguard measures which protect privacy to an adequate level through, for instance, the use of model clauses of binding corporate rules. Since 2001, PIPEDA meets this adequate level of protection. Accordingly, data transfers containing personal information of individuals residing in the EU to Canada are deemed acceptable and do not require further approval from European data protection authorities. It is therefore important for organizations doing business in Canada to comply with PIPEDA in order to validly process personal information from European data subjects. The US enjoyed a similar status to Canada as a jurisdiction providing adequate protection since 2000. Transfers of personal information of European residents from the EU to the US were acceptable when the US recipient complied with what was called the Safe Harbor Principles. Those principles were invalidated on October 6 of last year, following the decision of the EU Court of Justice in the Schrems case, which meant that the US no longer met the adequacy standard. Organizations that used to rely on the Safe Harbor Principles to transfer data from the EU to the US could no longer do it legally, except in certain situations, for instance, by amending the data transfer agreements with the European standard contractual clauses. This vacuum lasted 10 months. On August 1st of this year, the new EU-US Privacy Shield came into force. And as of 3 weeks ago, 200 companies applied to be accredited under this new regime, including large players such as Microsoft and Salesforce. Not directly. However, over the last few years, following continued revelations regarding US surveillance of Canadian data and Canadian citizens, the EU Commission's adequacy decision had been questioned. As I say to our clients, a robust data protection infrastructure is a competitive advantage for your business. Going forward, the new General Data Protection Regulation will replace the old Data Protection Directive as of May 25, 2018. As with the directive, the new regulation allows for transfers to countries such as Canada, which regime provide for an adequate level of protection. Even without an adequacy decision, and this may become more and more pertinent, transfers will be permitted outside of the EU if contractual arrangements with the Canadian organization comply with EU requirements. Canadian organizations collecting or processing personal information of European data subjects should be proactive and implement measures to ensure that privacy is embedded in their operations by design and by default. And when their solutions present a risk that is important for individuals' rights and liberties, perform a privacy impact assessment upfront to properly assess such risks. Also, since the new regulation includes new rights for European residents, such as the right to be forgotten, for instance, Canadian organizations should make sure that their solution enables the actual exercise of those rights. Finally, of course, you should review your agreement with European counterparts to make sure that it includes the required language and that you have adequate security policies, procedures, and technical measures in place to ensure that going forward, you will meet your legal and contractual obligations.
In February 2016, 12 countries surrounding the Pacific Ocean signed the Trans-Pacific Partnership Agreement, referred to as the TPP, including Canada, the US, Japan, and Mexico, among others, but does not include the EU. The TPP requires member countries to adopt or maintain a legal framework that protects the personal information of users of electronic commerce, taking into account principles and guidelines of relevant international bodies. The main purpose of the TPP is to facilitate global trade. From a privacy perspective, the TPP allows cross-border data flows and prohibits requirements that relate to data localization in non-financial laws. For example, mandating that a company's computer servers reside in a certain country. Each TPP member country is required to allow the cross-border transfer of information by electronic means, including personal information, when this activity is for the conduct of the business. The inference is that personal data, if for a commercial purpose, ought to flow freely between corporate entities of TPP member countries, irrespective of jurisdiction. In short, in the absence of a legitimate public policy objective, member countries are obligated to allow cross-border data transfers, including personal information, if such data transfer is conducted during the course of business and for a commercial purpose. Well, not really. In fact, there's a real potential for conflict. You may recall that the TPP bans data transfer restrictions between signatory countries. However, the EU regime contains an inherent restriction. It only allows data transfers to jurisdictions with laws that meet the adequacy standard for protection. As you can imagine, this core difference between the two regimes can create a real conflict. Taking into account Canada's TPP obligations, the 2001 adequacy decision from the European Commission with respect to Canada may be in jeopardy. If the adequacy decision is revoked, Canadian companies will need alternative protection in place to ensure they will continue to be deemed safe recipients of personal information from the EU. For Canadian companies working with organizations or other bodies located in Europe, it will be important to work proactively to establish rigorous safeguards that meet the GDPR requirements. Such measures may include standard data protection clauses in all contracts with an EU counterparty, and the implementation of a robust privacy infrastructure within the organization. For examples of other safeguards, or for more information on international privacy matters, we invite you to download our article by clicking on the link below or contacting any member of our cybersecurity group. Thanks for watching.